roll into the Zoom webinar. So we're just going to wait a second for that before we get started. All right. So welcome everyone. I think it looks like almost everyone's rolled in. So we'll get started. So I'd like to welcome you all to today's online charter series webinar on section 2A of the charter, which is freedom of conscience and religion, hosted by the Center for Constitutional Studies at the University of Alberta. We're so pleased to have you joining us today. My name is Alina Rjr. I'm the Center's Public Legal Education Coordinator, and I'll be moderating this session today. As this is a webinar, I know many of you may be watching from all across Canada, maybe even some different parts of the world. So I'd really encourage you to reflect upon the land at your respective location, wherever you are, and to think of those who came before you, who called and continue to call that land their home. The Center for Constitutional Studies is located at the University of Alberta in Edmonton, which is on Treaty 6 territory. The Center, the University and the city have enjoyed the benefits of treaty, and the Center acknowledges and honors the ancestors and traditions of this gathering place that first drew Indigenous peoples, the Cree, Blackfoot, Métis, Nakota Sioux, Iroquois, Dene, Saulteaux, Inuit, and later settlers. We acknowledge that we still reside on Treaty 6 territory and call upon the spirit and intent of treaty to maintain us in a stronger and lasting relationship. So before I introduce our speaker, Professor Howard Kislovitz, I'm just going to go through the format of today's webinar. First, you'll note that the chat function during the webinar has been disabled. So all our attendees, you can ask questions through the Q&A button that you see at the bottom of your screen. When you enter a question, other attendees will be able to see your questions, and they can, if you want, if there's a question that you see that you like or you have the same question, you can click the little thumbs up icon under it, and that will move the question up higher in our list. If you wish to ask a question anonymously, there is an option to do that when you're asking the question. So Professor Kislovitz is going to speak, and then we'll go on to the questions. And we'll see how many questions we can get through in the time that we have. Please also note that there's going to be a short feedback form or survey after the presentation today, and we'd really appreciate it if you take a few moments to provide us with your feedback. It's very valuable to us. Lastly, please note that the webinar is being recorded and it will be available on our website in the next few days. So our online charter series are intended to provide some basic information about specific charter sections, often in contexts that are relevant to current issues or events. And in today's webinar, Professor Kislovitz is going to discuss section 2A. Before I turn things over to him, I'd just like to provide a brief introduction. Professor Howard Kislovitz is an associate professor at the University of Calgary's Faculty of Law. He completed his graduate work, both in LLM and SJD at the University of Toronto. Prior to joining the University of Calgary in 2017, he worked as an assistant professor at the University of New Brunswick's Faculty of Law, and his research and teaching include the areas of constitutional and administrative law, as well as multiculturalism and religion and the law. He's published his work in numerous law journals and presented his research at national and international conferences. And if that wasn't enough to keep him busy, recently he also created a charter-themed sea shanty charter course with the assistance of other legal and musical minds and voices. And you can find that on YouTube if you're interested in checking that out. Just be warned, it will get stuck in your head if you listen to it. So be prepared for that if you look for it. So with that, I'm going to turn things over. And Howie, if you'd like to begin your presentation, please.
Okay, can you see that? Can you hear me?
We can see
working?
and hear you and see your PowerPoint.
Okay, wonderful. Well, thank you very much, Alina, for that generous introduction. And thank you also for inviting me to spend some time with you all today. And I'm coming to you from Calgary, so I'm in Treaty 7 territory. And I appreciate the reminder to think about the land on which I'm standing and how it filters into the discussion that we'll have today. As you'll see, places and spaces figure prominently in some of the cases that we'll talk about today. So I like to bear that in mind. So the topic, as I've been asked to address, is freedom of religion and conscience under the Charter. I thought it's always a good idea to get started with looking at the text of the document that we're talking about today. So we're interested today in the constitutional right of religious freedom. And so when we talk about the constitutional right, what we're talking about are the constitutional limits on government action, right? So this right doesn't regulate the relationship between individuals as much as it regulates the relationship between individuals or communities and the state. On the other hand. So these are limits to state legislative and administrative powers. So let's take a look at what the Constitution actually says. And here I'm looking specifically at the Charter. There is some reference to religion in our older constitutional document in the 1867 Act, but really most of the action that's happened in the last 40 years has happened under the Charter. So one curious thing to notice when we're first talking about the Charter is to take a look at the preamble to the Charter. So a preamble, for those unfamiliar, is often before a statute or a constitution gets started in terms of its main text. You'll see a series of phrases, usually starting with the word whereas, that are meant to convey the spirit of the document. They don't have binding force, but they can be a source of interpretation. So the Charter actually begins with the phrase, whereas Canada is founded upon principles that recognize the supremacy of God and the rule of law. So this is a bit of a controversial turn of phrase. I'm happy to answer questions about it in the Q&A. I think the short thing to take away from what's been made of this language of the supremacy of God is, so far in the Charter's 40 years, not very much. It hasn't really done a lot of work in the analytical steps that the courts have gone through when they're faced with religious freedom claims. But it is a bit of a puzzle how a document that in the first section that guarantees a freedom, so section 2A of the Charter guarantees freedom of conscience and religion, how can a document that guarantees everybody the freedom to believe or not believe, how can it also recognize the supremacy of a single God, which, as we know, is not a view shared by everybody in Canada. Some might have more polytheistic approaches, some might be atheistic, some might be agnostic. Those citizens also have freedom of conscience and religion. How are they supposed to do so under a document that has a monotheistic recognition? That's a bit of a puzzle that the courts have mostly sidestepped. The other section of the Charter that references religion directly is section 15 of the Charter, which is our equality right. And this is the right to be free from discrimination at the hands of the state. There are a number of listed grounds in section 15 that prohibit certain forms of discrimination, and religion is included among those. So when a state acts, when it has employment law or human rights laws, it must protect from discrimination on the basis of religion. By and large, cases that involve religion have mostly been analyzed under section 2A. We see much less work being done by section 15 of the Charter. So I'm going to focus on those cases that have looked at 2A. Now, a quick note before we jump into some of those cases. What I'm going to talk about in the next few minutes is to talk about what is included in the right of religious freedom, what is excluded from the right of religious freedom, and how under the Constitution, the right of religious freedom can be limited justifiably. So as many of you will know, the first section of the Charter is what we call the Reasonable Limits Clause. And that gives governments the ability to infringe on our fundamental freedoms, including freedom of conscience and religion, provided they can justify those infringements. And so I'll be talking about a few of those cases along the way. But before we get into those cases, one other puzzle about Section 2A is what this word conscience means. And we actually haven't had a ton of case law, almost nothing at the Supreme Court of Canada, to define what the Constitution means when it guarantees freedom of conscience. So there has been one case, I think, at the appellate level that has dealt with a claim for vegetarianism on behalf of an inmate at a federal institution. And that was recognized as a valid conscientious claim. And we have had some discussion in minority decisions about how freedom of conscience relates to a woman's privacy in the Morgenthaler decision from 1988. But that was a minority opinion, so we don't really have a majority opinion from the Supreme Court on what freedom of conscience means, even though the Charter has been in effect for 40 years. So another little puzzling thing about the Charter. Okay, moving along. So what is included, excuse me, in the right of religious freedom? The first case, actually, this is one of the first charter cases ever decided by the Supreme Court, was a case called Big M Drug Mart. And in our constitutional system, we're heavily influenced by a common law methodology. So the way we learn about what our Constitution means, or at least what our courts think our Constitution means, is through litigation, right? When there's a dispute. And Big M Drug Mart was actually a drugstore here in Alberta, where I'm sitting, and they had a problem with something called the Lord's Day Act. So this was a federal law that, by and large, made it illegal for retail businesses to open on Sundays. And Big M Drug Mart opened its business on Sunday, was faced with a fine, and then made the argument that the Lord's Day Act was a violation of religious freedom. Now, ultimately, they were successful in their argument. So the Supreme Court of Canada recognized that that Sunday closing legislation, which was motivated by a religious concern, was an unconstitutional violation of religious freedom, because the history of that act showed that it was legislated out of a particular Christian ethos of keeping a Sunday Sabbath free from commercial exchanges. But on the way to making that determination, we get a description of the concept of freedom of religion, which is cited in just about every subsequent 2A case, freedom of religion case. And it really helps us understand what is included in the right. So the Supreme Court of Canada held that the essence of the concept of freedom of religion is the right, one, to entertain such beliefs as a person chooses. Okay, so you have the right to believe whatever you want to believe. This is probably not likely to be subject to much litigation because, as of yet, the state can't read your mind, right? So it doesn't know what you're actually believing in your head and in your heart, but you do have that right. Where we start to get into more potential conflict is where people start to declare their religious beliefs openly, right? That's the second aspect of the right to declare religious beliefs openly and without fear of hindrance or reprisal, right? So this wasn't always the case in Canada. So we can think of the history, particularly of Jehovah's Witnesses in Quebec in the 1950s and 1940s and 50s, who were frequently the subject of government targeting, who did declare their religious beliefs openly, but were faced with reprisals from the government. The third aspect of the right is the right to manifest religious belief by worship and practice, or by teaching and dissemination. Okay, so you can do the rituals associated with your religious belief, or you also have the right to proselytize, right? This is what the Supreme Court means by teaching and dissemination. We can think of those as related, but really two aspects of the right. So this is the aspect of the religious freedom right that is the most likely, I think, to lead to conflicts, right? When does it matter to somebody else what I do? Well, it's only when I'm out in the open doing the thing that is somehow going to interfere with them, right? This is where we're going to see points of friction. But the Supreme Court says that is certainly included in the right. What else is included? Well, we move along until around 2004 in a case called Absalom. Now, Absalom is a really interesting case for a couple of reasons. One, it's interesting because it happens in a condominium. And so actually the Canadian Charter of Rights and Freedoms doesn't apply. The dispute is between 3 different co-owners in the condominium complex and the condo board. So as I said at the beginning, the Canadian Charter of Rights and Freedoms doesn't actually bind anybody in that dispute. But because this dispute happens in Quebec, it turns out to be a leading case in religious freedom. Why do I say that? Well, Quebec has a quasi-constitutional document called the Charter of Human Rights and Freedoms, and it guarantees many of the same rights that the Canadian Charter guarantees, including religious freedom. It's actually an older document than the Canadian Charter of Rights and Freedoms, and it applies in both the public and private sectors. So all contracts in Quebec are subject to the Quebec Charter of Human Rights and Freedoms. And the Supreme Court in the Absalom case goes out of its way to say, we're deciding this case under the Quebec Charter, but everything we're saying about religious freedom applies equally to Canadian Charter cases. So this has become the leading case on religious freedom in Canada, in part because it defines what the Supreme Court understands religion to be, as I'll talk about in a moment, and it sets a test for how to determine whether there has been a religious freedom infringement. So what happened in the case, just to give you a sense of where this all came from, the 3 co-owners in the condominium complex, they wanted to put up something called sukkot, or sukkah in the singular, on their balconies and terraces in this condominium complex. The problem was, if any of you have ever purchased a condo or lived in a condo, you probably know that one of the first things you do when you buy a condo is you have to sign on to the bylaws that are associated with the condo, which of course is this big and nobody ever reads. But in the bylaws, there was a prohibition on putting anything at all on the balconies and terraces. The idea of this prohibition was to maintain the aesthetic harmony and uniformity of the building, right? So that it would look a particular way. Now, these 3 co-owners, they wanted to install these sukkot on their balconies and terraces for a period of 8 days every year, associated with the Jewish holiday of Sukkot. And their argument was that the Quebec Charter prohibited the strict application of the nothing on the balconies rule, nothing on the terraces rule, because this was a religious festival. Now, ultimately, these co-owners, the ones who wanted to install these sukkot, they were successful. But again, on the way to coming to that conclusion, the Supreme Court does a number of interesting things. So as I said before, the first interesting thing that the Supreme Court of Canada does is it gives us a definition of religion. And I think it's worth reading just to get a sense of what does the court think religion means. And the court says, defined broadly, religion typically involves a particular and comprehensive system of faith and worship. Religion also tends to involve the belief in a divine, superhuman, or controlling power. In essence, religion is about freely and deeply held personal convictions or beliefs connected to an individual's spiritual faith and integrally linked to one's self-definition and spiritual fulfillment, the practices of which allow individuals to foster a connection with the divine or with the subject or object of that spiritual faith. Okay, so in these few sentences, we start to get an idea of what the Supreme Court of Canada thinks religion is and what it's for. And I would emphasize here that this is a particularly individualistic understanding of how religion works. Now, maybe that has its benefits, but it's certainly something worth noting. I've had questions before when I've presented this definition, well, what about Buddhism or forms of Buddhism that don't believe in a divine, superhuman, or controlling power? I think the answer to that is that the Supreme Court uses this language of tending to involve, rather than it being a mandatory criterion of what defines a religion. They're just trying to get a broad definition at the edges. I don't think there would be any doubt that Buddhism would qualify as a religion for the purposes of religious freedom. And there actually have been very few cases to date where the fight is about whether a particular belief is a religious belief specifically. So normally the parties are in agreement that the belief that's at issue is connected to religion. The fight is elsewhere, okay? Okay, so moving on. The Supreme Court in Amsterdam also sets a test, right? And this is why it's become the leading case. They set this multi-step test for what does a claimant, somebody who's saying their religious freedom has been infringed, what do they have to prove in order to force the government to justify its infringement, right? Because as I'll say in a moment, in charter litigation in general, it's the claimant or the individual's obligation to prove that their rights have been infringed, and then the burden switches to the government to justify that infringement. So the claimant has to prove first that they have a sincere belief that a particular practice has a nexus with religion, so it's connected to religion, and that that practice has been infringed in a way that is not trivial or insubstantial. Okay, so a few things to note here. First, in that first step of sincerity of belief, there's no need to prove that the practice is so quote unquote valid within a particular religious tradition. So this actually comes out very vibrantly from the way that the Amsterdam case was litigated, because this test had yet to be established. So what happens? Both the condo board and the co-owners, the ones who want to install the sukkot, they each call a rabbi as an expert witness as to what Judaism requires in terms of this obligation to build a sukkah. And the condo board's rabbi says Jews are not obligated on Sukkot to build their own sukkah, and the condo owners, the builders of the Sukkot, have a rabbi who says the opposite, that because of the obligation to enjoy the festival and celebrate it in a joyous way, any burden, which the condo board had proposed building a communal sukkah in the courtyard of the building, that was a long walk, and some of the condo owners were older folks. They said any burden would interfere with the obligation to celebrate the holiday in a joyous way, and that's why they needed to have their own individual sukkot, or each family needed its own sukkah. So the court sees this battle of dueling rabbis and says, I don't want to get in the middle of this, right? It shouldn't actually be up to courts to be the arbiters of what a particular religious faith requires, because that in itself would be a kind of religious freedom infringement. So the way the court solves this problem is by saying, as long as the person is sincere in their belief, that will be enough. So this opens the possibility that you could have theoretically a religion of one person, right? Or that one person could have their own variation on religious practice that maybe most people or nobody else in that religious community does the thing that the person wants to do, but nevertheless, that could come to be protected. And we don't typically see this kind of thing in litigation. Remember that in order to pursue a court case, a person needs to commit both time and money, generally, in order to pursue litigation. So generally, that has a way of filtering out insincere claimants. That being said, there's at least one case that I'm aware of where the court held that the person's claim to a religious belief was insincere because of past inconsistent behavior. So they have to show that they have a sincere belief. They have to show that it has a nexus with religion. And this means that both obligatory and voluntary practices are covered, right, by religious freedom for the same reason, right? The court says it doesn't want to be the body deciding what is required and what is voluntary in a particular religion, because that itself might be the subject of religious controversy, right? So you might, just as in the Absalom case, you see one rabbi saying having one's own sukkah is required in these circumstances, and another rabbi disagreeing. And the court says, we're the wrong kind of institution to solve this kind of disagreement. So their way around this was to say, as long as it's connected to religion, and it can be obligatory or voluntary, it's going to fall under the umbrella of religious freedom. And finally, the infringement has to be more than trivial or insubstantial. So this is a way of filtering out nuisance type claims, right? But I've written about this, and I think that there's a little bit of incoherence in this aspect of the test, because it turns what starts out as a very subjective test, so you're looking at the individual's perspective, into something like an objective test. What would a reasonable person think is a trivial infringement of their religious freedom? We don't have a great theory of this yet in Canadian law, but nevertheless, it remains an aspect of the test. I'll note that the Supreme Court of Canada has maybe only once relied on this idea of triviality to filter out a religious freedom claim. Since the 1980s, we haven't seen that at the Supreme Court of Canada. It has happened in some lower court decisions. Okay, so that's what's included in the right of religious freedom. What do we know about what's excluded? Well, we had actually a relatively recent decision in a case called Ktunaxa Nation. So as if I'm remembering correctly, it was a 2017 decision. And this was a dispute about a projected ski resort, right, in British Columbia, or what in an area that the Ktunaxa Nation calls the Katmuk. And the dispute was, the Ktunaxa Nation said that if anybody sojourned overnight or built a permanent structure in this particular area, that would cause the grizzly bear spirit, which was an important figure in the Ktunaxa Nation's cosmology, it would cause the grizzly bear spirit to leave, making meaningless any kind of rituals between the Ktunaxa Nation and the grizzly bear spirit. And the Supreme Court does something really interesting that I don't think we see in any other Commonwealth jurisdiction's definition of religious freedom. And it was very surprising to those of us who were watching because it hadn't been argued by any of the parties to the case. The court says that the spiritual focal point of worship is not included in the right of religious freedom, right? So from a monotheistic perspective, the way we might understand this is the right of religious freedom protects your right to worship your God, but it doesn't protect your God itself. Now, this has some pretty strange implications in my view. I'm happy to talk about those in the Q&A, but for today's purposes, I think just to note that if you're asking the court to protect your deity, you're likely going to be out of luck. So if you're trying to structure a claim that's going to be successful, it has to focus on the ritual itself rather than the object of the ritual or the focal point of worship. Okay. Last question on today's agenda before we get into the Q&A is, can the right be limited? And the answer is, of course it can, right? As I talked about a few moments ago, the very first thing that the Charter of Rights and Freedoms says before it gets into guaranteeing any of your rights is it sets out the ways in which your rights can be limited. So as many of you will likely be familiar, Section 1 of the Charter provides that the rights guaranteed in the Charter are subject to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. So this means that once a party establishes that their religious freedom has been infringed, okay, so let's say they satisfy the test in Amsterdam, which turns out to be a pretty easy burden for most claimants to satisfy. It doesn't take a lot of evidence to demonstrate an infringement of religious freedom in our experience here in Canada. Usually, the real fight is around whether the infringement is justified. Now, since the 1980s, the court has relied on the framework set in a case called the Crown and Oakes, O-A-K-E-S, to analyze whether an infringement of a charter right, including a religious freedom right, has been demonstrably justified within the reasonable limits of a free and democratic society. And the Crown or the party trying to justify the infringement must demonstrate that there was a pressing and substantial objective underlying their law. They must demonstrate that there's a rational connection between that objective and the law itself. They must demonstrate that the law is minimally impairing of the right. So it couldn't have achieved its goal in a way that more minimally impaired the right of religious freedom. And I'll give you an example of that in a moment. And the final thing that the government usually has to prove is that what we call the proportionality of effects. The court uses the language of balancing the salutary effects of the law against its deleterious effects. I don't know why such fancy language is required. This is basically a pro and con sheet, right? We're looking at an analysis of the good things the law does against the bad things that it does, and the bad things usually include the violation of of the charter right. Now, most of the time, the government has an easy time showing that there was a pressing and substantial objective, that it's rationally connected and that is rationally connected to the law. Where the fight usually happens is around minimal impairment. Could the government have achieved its goal in a way that more minimally impaired the constitutional rights at stake? By and large, the last step follows minimal impairment. So if the government fails minimal impairment, they're likely to also fail the proportionality of effects. And likewise, if the government passes minimal impairment, they're likely also to pass the proportionality of effects. Now, it's worth noting that the government needs to win each of these arguments. Okay, so it's not a question of 3 out of 4 and you pass. If the government fails on any one of these steps, that's it for the law. It's unconstitutional. So just to give you an example, actually the one that happened here in Alberta in a case called Hatarian Brethren. So what happens in the Hatarian Brethren case is you have a subset of Hutterites, which is a small religious minority concentrated mostly here in Alberta, but also in other parts of the prairies, who believe that the prohibition on graven images in the Ten Commandments actually prohibits all imagery, all representational artwork, including photographs. And the government of Alberta wanted to create a digital database of photographs on driver's licenses and make it so that having a photo on your driver's license was universally mandatory. Now, since the 1970s, Alberta has had photos on its driver's licenses, but for the first 30 or so years of that requirement, there was built into the law a religious exemption specifically for this subset of Hutterites who object to having their photos taken. Once the government decided to use those photos as part of a digital database, it made that requirement universally mandatory. And the Hutterites objected. They say that this was a violation of their religious freedom. Now, it was conceded, it was admitted by the government that this was a religious freedom infringement. Where the fight happened was, again, in this justification stage under Section 1. And what the court ends up saying in this case, which is it's a pretty significant movement on Section 1 more generally, is that when we're thinking about minimal impairment, we have to think about the objective of the government that we've already determined was valid. And the government must be allowed to substantially achieve its objective. And anything less than a substantial achievement of that objective shouldn't hang in the balance. The question is, could the government do what it wanted to do, complete its objective, while more minimally impairing the right? And the way that this case was fought out was the government argued that its goal was to have an as secure as possible digital database, and any exemption from the photo requirement made that database somewhat less secure. So the majority of the Supreme Court of Canada holds that this met the standard for minimal impairment, that not allowing this exemption was consistent with minimal impairment because there was no other way in the court's judgment for the government to substantially complete its goal. And so therefore the Hutterites were unsuccessful in this challenge. One other thing to think about when we're thinking about whether the right can be limited, often, and perhaps more often in recent memory, constitutional rights are limited by government action rather than by legislation. So it's a very common thing for governments, both federal and provincial in Canada, to delegate decision-making authority to some designate, right? So sometimes that's a minister, sometimes it's a board, sometimes it's a tribunal. When those government delegates are acting, they don't make a law. They're making a decision that is delegated to them under the law. Now, when those kinds of decisions impact charter rights, the analytical frame is somewhat different. But again, they're focused mostly on this idea of proportionality, which, as I said, when we're talking about a law and we're looking at minimal impairment, we're really thinking about proportionality. It's an aspect of what we call the proportionality analysis. So just to give you one example of this idea in action, there was a case called Loyola that arose in Quebec. And the case really started when Quebec's Minister of Education decided that there would be a new curriculum of ethics and religious culture that would be universally mandatory, and schools were required to teach this in order to meet their obligations under the Education Act and maintain their funding, right, significantly from the government. So what happens in Loyola is you have this Catholic school in Montreal that says, we teach about ethics and religious culture, but we teach about it from a Catholic perspective. And this particular curriculum requires us to teach about all religions from a so-called neutral perspective, which we can't do from in our religious way of engaging with the world. What the court ends up saying in Loyola, it's a really interesting understanding of proportionality here. The court ends up saying that the government can force a Catholic school to teach about other religions from a neutral perspective because of the importance of learning about other people's views in a less than in a non-disparaging way, right? That these are options that other people use. So requiring any school to teach about those from a neutral perspective is okay. But on the other hand, the government cannot require a Catholic school to teach about Catholicism from a neutral perspective. Right? In order to respect the value of religious freedom, the government must allow Catholic schools to teach about Catholicism from a specifically Catholic perspective. Okay, so this really shows how the proportionality decisions can be really nuanced. So that, you know, the claim from the school was we ought to be exempted from this program entirely, and the court says, well, you can be exempted from the part of it that deals with Catholicism, but you can be required to teach about other religions from a neutral perspective. So that's just one example to see how a government decision can be subjected to this proportionality requirement. So that concludes my planned remarks for today, and I'll be very pleased to talk about some of your questions.
Well, thank you so much, Howie. That was, I think, a very thorough and clear outline of religious freedom under the Charters. Thank you so much. We do have a number of questions. Just a reminder for attendees, if you want to ask a question, just use the Q&A button that you'll see at the bottom of your screen. If there's one you like or you have the same question, you can hit the thumbs up sign under a question that you see and it'll bump it up. So we've got quite a number rolling in. I'll read them out for you, Howie, and if there's ones you're quite excited about, just let me know. We can hop to that. So it looks like someone's taken up your offer to talk a little bit more about the preamble. The question is, could you say that the reference to God in the preamble of the Charter just recognizes the existence of a higher system of principles or morality under which laws must conform?
I mean, I could say it. And I think one could say it. So some, I'm sorry, I'm being a little facetious there, but some people have made that argument, right? So some scholars have tried to say, well, how do we reconcile this tension between the supremacy of God clause and the guarantee of religious freedom? I think maybe the most subversive take I've heard on this is in a case I didn't talk about, a case called Saguenay, which recognizes the duty of religious neutrality on states, from which the court reasons that a municipal council cannot begin its sessions with a monotheistic prayer, right? Because of the exclusionary effects that has on citizens who are atheistic, agnostic, polytheistic, who just don't share that worldview. So that was unconstitutional. And somebody, I think, very subversively suggested, well, what if they just started by reading out the Charter? How could reading the preamble to the Charter be unconstitutional? You're actually reading the Constitution, right? But that was the problem with the prayer, right? That it was monotheistic in origin. So it really is a puzzle. So some people have said that when we're talking about the supremacy of God clause, what we're looking at is a reference to the natural law tradition from which individual human rights stem, right? So if you think more broadly about why we have human rights, the court has said that the thread that ties all of these fundamental rights together is the respect of human dignity, right? That violating these rights is somehow an affront to something that makes us human, right? That dignity that we say separates us from other species, right? So this reference to the supremacy of God is kind of, it used to be that this natural law tradition from which this inherent human dignity stemmed was directly tied to God, right? So we have this human dignity on this theory because God plants it in us and we are a reflection of the image of God. And that's what makes it such a problem to violate these fundamental rights. Now, current theories of human rights tend to be less theistic, right? Or at least the predominant ones. They tend to just stop at human dignity. They don't say we have human dignity because God gave it to us. We just have human dignity because we have human dignity. That's where it ends. That's where the analysis ends. And so some have tried to say that that's what the supremacy of God is a placeholder for. I think that there's a really interesting suggestion in the Saguenay case that this preamble embodies what the court calls the political theory of the charter, and it doesn't really explain what that means. I think, and I'm planning to write about this, I hope, I think that that's a nod to some pre-charter cases authored principally by Justice Rand of the Supreme Court of Canada, who found certain unwritten constitutional rights that he said were embodied in the way we do government. Right. So in his view, the Constitution before the Charter protected things like freedom of expression and freedom of religion because it was premised on the idea of a democratic system of government. And you can't have, in Justice Rand's view, I'm abbreviating it here, but you can't have, in Justice Rand's view, a democratic system of government without protecting freedom of expression and freedom of religion. Those were an aspect of democratic life for Justice Rand. I wonder how those things are connected. I wonder how the reference to the supremacy of God is connected to this idea of the political theory of the Constitution.
Thank you so much. That's really quite fascinating. I hadn't really thought about that much before, so that's quite fascinating. So our next question here is, how did the recent BC decision address or justify the proportionality test regarding the complete prohibition of church services during the pandemic, i.e., given that people can gather or be under the same roof for other purposes with some limits rather than complete prohibition?
I have to confess, I haven't seen the judicial decision from BC. I've seen the decision from Newfoundland that talked about the travel restrictions. So I can't comment directly on what the court in BC said. But my guess is that it relates to the minimal impairment analysis, right? That especially in an emergent situation where governments have incomplete information, courts are likely to be deferential to government when they're trying to act for a valid purpose. In this case, it would be advancing public health rationales, right? So preventing the spread. Now, governments don't have to do everything that's available to them in order to meet their objectives, right? They can adopt intermediate measures. So we see this outside the religious freedom context. We see it in a case called Rjr Mcdonald, which is a case about the prohibition of tobacco advertising, right? So one of the arguments in the case is, well, that's a violation of free expression. Why don't you just ban tobacco? And the Supreme Court was unanimous in saying, no, that it is still open to the government to pursue alternative measures. They don't have to do everything that they're constitutionally entitled to do. The question is, have they violated the Constitution in acting? Now, the argument that that religious services are treated differently from other analogous activities, that would factor, I think, more in the equality analysis, because what we're doing is we're comparing how religious activities are treated relative to other similar activities. And in that case, the analysis, I think, would really be factual, right? Are these religious activities really, in fact, similar in terms of their likelihood to spread disease, and was the government reasonable in drawing its lines? So that's how I would assume it would go, but I confess I'm not fully up to date on what the BC court said.
Thank you so much. So the next question is, do you think that courts following the Supreme Court tend to consider freedom of religion charter claims using the Section 2.8 framework rather than the Section 15 framework, because Section 15 might lead to more claims of government support for religious practice or teaching?
I'm not certain I understand the question. I'm sorry, let me read it again. I'm not sure how the Section 15 framework would lead to more claims of inappropriate government support for religious practice teaching, I suppose, is the argument. So the closest case that I can think of on this topic is a case called Adler. And it's a case that where some families in Ontario challenged the government's practice of funding Catholic schools, but no other religious schools. So Ontario is unique in that way in Canada. So we have a different pattern of support for religious schools across the country. Some provinces give no support to religious schools, I think is the case in British Columbia. I may not be sure about that. Some provinces like Alberta give some measure of support to religious schools, but only Ontario funds only Catholic schools and no other religious schools, right? Other provinces, if they support Catholic schools, they also support other religious schools. So this was objected to by some Jewish and Muslim families, I believe, in the 1990s in a case called Adler. And the problem in Adler was that Ontario actually has a constitutional obligation under Section 93 of the 1867 Act, so the older part of our Constitution, to fund those Catholic schools. So the answer in that case was, you can't use one part of the Constitution to attack another, right? So we did actually have a view from Chief Justice McLaughlin, who went into the Section 15 analysis and made that kind of argument, and she was prepared to recognize an infringement there. But I'm not certain. I would want to hear more from the person who asked the question as to why they think the Section 15 framework would tend to reinforce that view. I just haven't thought it all the way through, and I'm curious to hear what they think. But maybe we'll get there another day. I don't know if it was an anonymous question, so I don't know how we reach back out to that person.
Well, thank you so much. So the next question, they thank you, and they're wondering what your thoughts were on the implications of the College of Physicians and Surgeons Ontario and Christian Medical and Dental Society on the Oakes analysis. So this section 1. They say, it seems to me that the courts at the trial level and appellate level took a largely deferential posture when it comes to infringements to Section 2A rights, in particular when the government is alleging a concern, such as safety in Multani or access to healthcare in the above mentioned case. This seems to be a shift from Multani, which required that these concerns be unequivocally established on the record before justifying an infringement. The courts in Christian Medical acknowledged that there was no direct evidence on whether religious physicians impacted access to healthcare. So are these cases reconcilable?
Yeah, no, really interesting question, right? So this is a case that didn't get leave to appeal from the Supreme Court of Canada. So what we're looking at is a decision from the Ontario Court of Appeal. As the person who asked the question says, what this case is really about is the Ontario College of Physicians and Surgeons policy of effective referral to the process of medical assistance in dying, but it also applies to things like access to abortion, as far as I understand it. So the college, which the college acts as one of these delegates of government authorities. So the reason that the college can bind its members, the physicians that treat all the people in Ontario, is because the government gives it that power to regulate the practice of medicine. So we're looking at a Loyola type situation in terms of the kinds of cases that I already talked about today. So the college says, if you want to practice medicine in Ontario, we're not going to obligate you to participate directly in providing medical assistance in dying or providing abortions if those violate your religious views, but we are going to argue require you to make what we call an effective referral. So you have to be able to direct your patients to somebody who will at least give them that option if it's appropriate in their cases. So what this questioner, I think, very astutely asked is, in a case called Multani, which is another one I didn't talk about, this was a case about whether a student could bring a kirpan to a Quebec public high school. And the way that the case shook out, I think that they potentially are distinguishable. And the reason I think they're distinguishable is the way that the court handled Multani was by saying the school board's policy, they said in court that they had a policy of absolute safety, but their practice belied that assertion. I think what was most convincing in Multani was that the schools didn't prohibit all dangerous objects, right? So they didn't prohibit baseball bats, they didn't prohibit geometry compasses, they didn't prohibit pens, they didn't prohibit knives in the cafeteria. All of these things are potentially dangerous if used by somebody in a threatening way, right? Or in a violent way. And they prohibited this kirpan despite not having any evidence in the record that a kirpan had been used in a school in a violent way anywhere by anybody in the history of the world, right? They didn't have any of that evidence on the record. So the court was saying to the school board, you're acting inconsistently because your policy is one of reasonable safety rather than absolute safety. So prohibiting the kirpan is actually inconsistent with your own policy, right? Whereas in the Christian Medical and Dental Society case, I'm not sure that such a parallel argument is available, right? Because the College of Physicians and Surgeons is going to argue that its policy is of ensuring the broadest possible access of patients to medical care. And the idea that they only provide reasonable access, and that's why, and to make a completely analogous argument to Multani, I think that that might be the disanalogy. I think that might be the distinguishing factor between the cases. But I take the point that on the evidence, and I have to go back and check what was on the record, but I take the questioner at face value when they say that the physicians and surgeons didn't have evidence that allowing for objecting physicians to not make effective referrals compromised access to healthcare. I take the point that the evidence is treated differently, right? I think that that's probably true.
Thank you so much. So the next question talks a little bit about taxation law. So it says, must taxation law give tax-free status to religion because of the charter right? Does tax law therefore provide definitions or requirements as to what constitutes a religion?
So the short answer is yes, sort of. And I'll direct you to the work of Catherine Chan, who is a professor at the University of Victoria and somebody who I've co-authored a bit with. She is, to my mind, if you could have had her, it would have been great. She is, to my mind, the leading author in this area because she has quite a bit of, she's probably the strongest expert on charities law in academics in Canada, and she's interested particularly in this question of religions under charities law. So I would refer you to the writings of Professor Chan. I don't think that there is, that there's ever been a case that says the religious freedom requirement amounts to an obligation on the government to these kinds of tax-free exemptions, right? These exemptions for religious institutions under tax law are older than the charter, right? The idea that religious activities count as charitable activities, that is a very old common law idea that has worked itself into our law. The question, I think, would be, in answer to the questioner here, is what would happen if the government took that away, right? If the government said tomorrow, charitable purpose doesn't include religious activities, right? You have to be doing something to help somebody else, and we're not going to count maintaining a religious community as that. I mean, I think that's a very, that would be a very problematic attitude, but let's say the government took that position. Would that be a violation of religious freedom? That's a really challenging question because the government isn't prohibiting you from doing anything, right? The government isn't saying you can't have your congregation anymore, but you might end up with congregations that find themselves in really difficult financial situations, right? The only way they can maintain the properties that they have or the leases that they have is by offering these charitable tax receipts so that their donors don't feel the impact, the financial impact of their donation in the same way, right? So would that mean that all of a sudden we'd see the evaporation of religious congregations around the country? Perhaps. And if those facts could be established, then maybe a Section 2A claim would be developable. But it's still a challenging case to meet because I think what you're asking for is a positive rather than a negative right, right? And sometimes this distinction is a little bit malleable, but what you're saying is that my right of freedom of religion requires the government to do a thing. It requires the government to give me this tax exempt status. We haven't seen those arguments recognized very easily. Mostly Section 2A has been treated as a negative freedom in that it prohibits the governments from doing certain things.
Thank you so much. So the next question, it's a little bit of a multi-parter. I think what they're trying to get at is partly, what sort of religious activities might be found that it would be okay to infringe them. And then as well, I think how you define religion, I think is part of it. The question is, when can one's freedom of religion be infringed? For example, freedom of religion and mental illness. If you're in danger to yourself or others, can your religious freedom be infringed? They give the example of fasting to the point of damage to health. I'm not sure what the second part says, misrepresenting religion leaders where one might interpret them wrong and not allowed to do so. And then 3, misguided to the point of danger, thus one might consider a mental illness. So basically, when is a religious consciousness a mental illness? So I guess that goes to the definition of what is a religious belief or practice.
Sure. Well, we haven't had cases to my knowledge around fasting, but we have had cases around the refusal of blood transfusions. So as you might know, for many Jehovah's Witnesses, taking blood transfusions is prohibited. And the answer that we get from the courts typically has divided around where we allow people to make medical decisions for themselves. So it's clear that an adult who might not meet the criteria of whatever mental illness, like mental incapacity that we see, so that somebody else should be making their medical decisions. So if there's a person who holds this belief as Jehovah's Witness and says, I don't want a blood transfusion, then their decision can't be overruled because of our respect for their autonomy, unless there's some kind of mental incapacity, right? In basic, I mean, I'm not an expert in health law, but this is how these things tend to work out in the cases that I'm familiar with. So there's a famous tort case where a doctor who becomes aware of a person's objection to receiving blood transfusion and then does the transfusion anyway is guilty of the tort of battery, right? Interfering with their body in a way that they hadn't consented to. On the other hand, for children, what we'll often see is the state taking a wardship order over those children and making their medical decisions for them. So these are heartbreaking cases, right? But sometimes you see there's a baby, the doctors say they need a blood transfusion, or their health chances will be improved by receiving a blood transfusion. The parents say, we can't have our baby have a blood transfusion because in our way of thinking, the consequences of taking a blood transfusion are much worse than the consequences of dying, right? So in those cases where the state takes a wardship order and consents on behalf of the child to receiving a blood transfusion, the courts have said that that's a justifiable infringement of religious freedom. So it's still an infringement, but it's one that's justifiable. Where we get really challenging, I mean, these cases are hard enough, but where we get really challenging is around what we call mature minors, right? So somebody who's 14 or 16, so they can't vote yet, but we do let them make other medical decisions on their own behalf for perhaps some very good reasons, right? So you might really want to allow, teenage girls to be able to talk to their doctors about birth control or abortion options in a way that doesn't require parental approval, right? There might actually be a very compelling public health value behind allowing for them to make their own medical decisions without their parents' permission. Well, what if those same children that same age want to make the decision to refuse a blood transfusion? And the courts have basically held that as long as the mature minor doctrine is in operation, once we consider them a mature minor, we have to basically treat their decision as if they were an adult. And if they will refuse the blood transfusion, then we have to respect that decision. So I think that answers the first part of the question. The second part of the question was about interpreting a religion in a way that's different, I think. And I think that the Absalom case really answers that question, that it doesn't really matter what the religious leader says the religion requires, right? So if I go to court and say, my Judaism prohibits me from doing this thing, and the other side wants to call a rabbi that says, well, Judaism has no such prohibition, it doesn't really matter as long as I'm being sincere, right? So they can't attack the belief itself. They can only attack whether I'm lying about it. And so I might want to call an expert witness, maybe a rabbi, who says, well, it's not a majority view, but it is somewhere in the tradition, just to establish that I'm being honest. But the legal question is not whether it's a valid practice, it's whether it's an honest belief, a sincere belief in the practice. I'm not sure if I remember the last part of the question.
I think the last question had to do with establishing, and I think you answered a little bit when you talked about blood transfusions, was I think essentially establishing when is it a religious belief versus perhaps maybe a delusion or something due to a mental health issue.
Right. So my guess is that would mostly be resolved on the basis of the medical evidence, right? So we would turn to questions of capacity that would be resolved under a different framework, right? So if the person had some kind of mental illness that was leading them to be incapable of making their own decisions, and this is an area that I'm less familiar with, but my guess is that that's how that would sort out. So we would use a different framework. It wouldn't really be done within the religious freedom framework.
Thank you so much. Let's see, maybe we can tuck in one last question because we're getting to
Sure.
time. Does our legal tradition view freedom of religion as a subset of freedom of conscience, or vice versa, or both as independent of each other?
So the answer is we don't know. Like the courts haven't addressed that question. So on one, I think either view of that question would be valid arguments. So you might say that, well, we start with conscience and then we say religion. And so we're going from the more general to the more specific. And the religious belief is really kind of a paradigmatic example of a conscientious decision, right? Or you might say, well, we use the word and the word and might suggest that we're talking about two different things, even though they're included in the same right. They're somehow related, but they require some independent meaning. I think we could have different theories about what the right of freedom of conscience is and how it's different from the right of religious freedom. So you might say that conscience is more about individual decisions, and religious freedom, even though we could theoretically have a religion of one person, in real life, religions tend to involve some communal aspect. And so that's the religious freedom part versus the conscientious part. Or we're trying to have some kind of functional equivalence. So the role that a worldview plays in a person's life. So you can have, in a country that has a mandatory military service draft, for example, you could have a conscientious objector who's not drawing on any religious tradition. But if their moral worldview fills the same role in their life as religion does, then we're going to recognize it as a conscientious freedom case. So this is how some of the American cases in the 1940s treated this mandatory military service requirement. So there's lots of possibilities. We don't actually have an answer from the courts. And the way our system works is that we kind of have to wait for the courts to interpret in order to fully understand what the rights mean in our legal system. Now, of course, you're free to disagree with the courts. And that I think that's another aspect of our legal system. You can say they got it wrong, but ultimately they're the ones who make the binding decisions for us.
Thank you so much. We're at time. So I'm sorry we weren't able to get to all the questions, but we certainly appreciate all those wonderful questions and discussion. So thank you so much, Howie, for sharing your knowledge and experience and time with us, and taking the time to answer the questions from our attendees, and for such an insightful and informative presentation. We really appreciate that you're able to spend some time with us this afternoon. The center will be making a donation to the food bank on your behalf in recognition of your time and effort in this presentation. So thank you so much. I'd also like to thank Zara Ahmed, our administrator, and Patricia Parody, our executive director, who helped with organizing, advertising, preparing for this webinar. And thank you so much to all of you who attended today. We really appreciate your interest and attendance, and I hope you found this webinar interesting and that it really helped increase your understanding of the Charter, and that you'll continue to join us as we plan new events moving forward. This webinar will be recorded and it will be available on our website soon, so if you want to rewatch it or you missed it or you want to share it, you'll be able to do that. Lastly, just a reminder, you'll see a link to a short feedback form when this webinar ends, and we would so appreciate it if you take the time to fill it out, because audience feedback is critical to our funding and to our future programming. So thank you so much, everyone. Have a lovely afternoon.
Thanks, everybody. It's been fun.